Are millions of gun owners with pistol braces felons again? For years, that question has been hanging over everyone's head. The ATF kept changing its mind. The courts stepped in, and nobody had a clear answer. And what about ghost guns? The Supreme Court has now had its say, and the world of building your own firearms has been changed for good. The federal government has dropped some massive new rules, but the truth is, what's legal and what isn't has gotten complicated. But the truth is, what's legal and what isn't has gotten complicated. It's not one size fits all. And what's fine at the federal level could still land you in a world of hurt depending on where you live. In this video, we're cutting through the noise. We're going to break down exactly what has changed federally for pistol braces and home-built guns as we head into 2026. But more importantly, we'll be getting into the state-level laws you absolutely cannot afford to ignore. The federal rules are only half the story. The other half is being written by your state, and that's where the real fight is happening right now. We have a lot to get through, so let's get to it. The whole pistol brace saga has been one of the most confusing and frustrating battles for gun owners in recent memory. Let's do a quick recap. Back in January 2023, the ATF dropped its infamous final rule, which basically redefined a rifle to include pistols with stabilizing braces. Overnight, millions of law-abiding Americans who owned AR pistols and similar firearms were told their guns might now be illegal short-barreled rifles, SBRs, putting them on the wrong side of the National Firearms Act, NFA. The ATF's guidance was a total mess, using a vague, subjective worksheet that left even gun dealers guessing what was legal. The options they gave owners were terrible: destroy the brace, put on a 16-inch barrel, destroy the gun, or register it as an SBR. They offered a 120-day tax-free amnesty period for registration, but it felt more like forced compliance. This, of course, triggered a massive and immediate legal backlash, and that pushback worked. Throughout 2024 and 2025, the courts handed the ATF a series of devastating losses. Federal courts, including the Fifth and Eighth Circuits, ruled that the ATF had gone way beyond its authority. The final nail in the coffin came in mid-2025, when the government agreed to drop its appeal in the key case, meaning the district court's ruling that vacated the rule nationwide now stands for good. It is officially dead and unenforceable. So, what does this mean for you in 2026? At the federal level, the panic is over. A pistol with a stabilizing brace is not automatically an SBR. The legal status has gone back to how it was before the 2023 rule was ever thought up. Braces themselves are just accessories. But hold on, because that's not even the biggest news. In a totally separate but game-changing development, legislation known as the One Big Beautiful Bill Act was signed into law on July 4, 2025. As of January 1, 2026, it eliminates the $200 NFA tax stamp for suppressors, short-barreled rifles, short-barreled shotguns, and AOWs. Let me say that again. The $200 tax is gone. The NFA registration process, the paperwork, and the background checks all remain, but the huge financial barrier to owning these items has been completely removed. This is a seismic shift. For decades, that $200 tax stopped a lot of people from even thinking about an SBR or a suppressor. Now, if you want to build a short-barreled rifle, filing the ATF Form 1 costs you nothing. This completely changes the math. While the brace rule was defeated, making braced pistols federally legal again, the removal of the tax stamp makes building a true SBR more accessible than ever before. So your takeaway is this: while braces are legal accessories, the NFA still exists. The huge difference now is that choosing to register a firearm as an SBR is no longer an expensive decision. Just remember, and we'll get into this more, your state might have its own separate bans on SBRs that you still have to follow. The second major federal change is all about privately made firearms, or what the media loves to call ghost guns. For years, the focus of gun control groups has been on the sale of firearm parts kits, which contain an unfinished frame or receiver and all the other parts needed to build a working firearm at home. In 2022, the ATF issued its Frame and Receiver Rule to tackle this. The rule expanded the definition of a firearm to include weapon parts kits that can be readily converted into a functional gun. The goal was to force companies selling these kits to serialize the frame or receiver and require buyers to go through a background check, just like buying a finished gun. Of course, this rule was immediately challenged, and the case, UIP Bondi vs. Vanderstock, went all the way to the Supreme Court. The final decision came down on March 26, 2025. In a 7-2 majority opinion, the Supreme Court upheld the ATF's rule. The court reasoned that the Gun Control Act's definition of a firearm was broad enough to let the ATF regulate kits that are clearly designed to be turned into a weapon. So what does this landmark ruling mean for you? It's really important to know what this decision does and doesn't do. The Supreme Court's ruling means the ATF can regulate the commercial sale of weapon parts kits. If you go to buy an 80% lower kit that comes with the jig, drill bits, and everything else you need to finish it, that whole package is now treated as a firearm. The seller has to be a licensed dealer, the part that becomes the receiver must be serialized, and you have to pass a background check to buy it. The days of getting a complete kit in a box shipped to your door with no paperwork are over. But here's the most important part. The court drew a very bright line. The ruling in Bondi vs. Vanderstock applies to the commercial sale of kits. It does not make it illegal for you to make your own firearm for personal use. The act of building a gun at home, federally, remains legal. If you buy an unserialized block of metal that isn't yet a receiver and then get the other parts for your build from different places, you haven't bought a kit, as the ATF rule defines it. The federal government has not banned building your own gun. What it did was regulate the easy, all-in-one commercial products that made it so simple. The bottom line, buying a complete kit now means a background check and a serial number. Building a gun for yourself from scratch, as long as you don't sell it, is still federally protected. But just like with pistol braces, that's only the federal side of the coin. The states are taking a much more aggressive approach. We're about to jump into the tangled mess of state laws, and this is where things get tricky and the consequences for not knowing the rules are serious. But first, if you're finding this breakdown useful, take a second to subscribe and hit that notification bell. The laws are always changing, and our job is to keep you informed so you can stay safe and legal. Your support helps us keep making this content. Also, drop a comment with your state and what questions you have about its laws. We try to read through them and tackle them in future updates. Welcome to the most important part of our discussion. While the feds have set a new baseline, the real legal minefield for gun owners is at the state level. In some states, the legislative reaction has been aggressive, creating a patchwork of rules that can easily turn a law-abiding citizen into a criminal. A gun that's perfectly legal federally can become a banned assault weapon or an illegal, untraceable firearm the moment you cross a state line. Let's look at a few examples. First, California. For 2026, California has unleashed a ton of new restrictions with bills like AB 1263 and SB 704. These laws essentially declare war on home-built firearms. It's now a crime to knowingly or willfully help someone unlawfully manufacture a firearm, which is broad language aimed at shutting down the sharing of digital files, like 3D printing CAD files. On top of that, SB 704 now requires that the sale of standalone firearm barrels must be done in person through a licensed dealer, starting January 1, 2026. California is trying to make building a gun for personal use impossible by attacking the components themselves. Next up, Massachusetts. The state passed a huge gun control bill in 2024 that's now being implemented. The biggest deal for gun owners is the new registration mandate. A recent guidance letter confirmed that all firearms in the state must be registered with the government by October 2, 2026. This includes privately made firearms, which must have a serial number engraved on them according to state standards. Massachusetts isn't just targeting ghost guns, it's creating a full registry of all guns and gun owners. Then there's Washington State. The legislature has been relentless. While a 2023 law already banned many semi-auto rifles, new rules are targeting pistols and gun ownership in general. For example, House Bill 2118, which is now in effect, forces strict new regulations on gun dealers, including 24/7 video and audio surveillance of their shops. Other bills proposed for the 2026 session are even more alarming. House Bill 1152 would mandate the secure storage of all firearms in homes and vehicles, while Senate Bill 5098 aims to dramatically expand gun-free zones to include parks and any place children are likely to be present. Washington's strategy is clearly to make owning a gun as legally risky and expensive as they can. The key takeaway for every single person watching is to stop thinking about gun laws as just a federal issue. You must know your state and local laws. What's legal in a state like Florida could get you a felony charge in California or New York. The fight for your Second Amendment rights is no longer just in Washington, D.C. It's in your state capital. While some states are clamping down hard, there's a powerful countertrend sweeping across the rest of the country: the expansion of constitutional carry. As of early 2026, an incredible 29 states now allow law-abiding adults to carry a concealed firearm without needing a government permit first. This list includes states like Florida, Louisiana, and South Carolina, which have joined the movement in just the last couple of years. This trend is the polar opposite of what's happening in states like California and Washington. While one half of the country is adding layers of bureaucracy and restrictions, the other half is tearing them down. In permitless carry states, the attitude is that if you can legally own a gun, you can legally carry it. This movement is a powerful statement that the Second Amendment is a right, not a government-granted privilege. Another major trend we already covered is the reform of the National Firearms Act. The elimination of the $200 tax for SBRs and suppressors is a monumental victory that can't be overstated. It makes NFA items more accessible to the average American. This change was the result of years of hard work and signals a huge shift in thinking, admitting that these items are in common use, and the tax was just a barrier, not a safety measure. The key takeaway from these national trends is that the fight is moving in two directions at once. Pro-rights advocates are winning huge victories in half the country and with NFA reform, while anti-gun states are digging in and creating legal islands where the Second Amendment is barely recognized. So after all that, what are the key takeaways for you in 2026? First, on pistol braces, the ATF's 2023 rule is dead and gone. Federal courts vacated it, and the government gave up the fight. You can legally own and use a braced pistol at the federal level without worrying about it being called an SBR. Second, in a massive win, the $200 NFA tax stamp for suppressors and SBRs is gone as of January 1, 2026. You still have to do the paperwork, but the biggest financial hurdle to owning these items has been removed. This is one of the most significant pro-gun reforms we've seen in decades. Third, when it comes to ghost guns, the Supreme Court has made its decision. The ATF can regulate the sale of all-in-one weapon parts kits. If you buy a kit, expect it to be serialized and require a background check. However, the ruling did not ban you from privately making a firearm for your own use. That is still federally protected. Fourth, and most importantly, your state laws are everything. The federal rules are only half the picture. States like California, Washington, and Massachusetts are spinning their own webs of registration, component bans, and carry restrictions that can easily trap you if you're not informed. A braced pistol that's legal federally might be an illegal assault weapon in your state. The bottom line is this: you have to be more informed and engaged than ever. Know the federal laws, but become an expert on your state and local rules. The Second Amendment isn't a right that enforces itself. It requires constant vigilance from all of us. Stay informed, stay legal, and stay safe.